Archiving started.
Welcome to the second half of the lecture on Chapter 6, which deals with real and intellectual property. During this presentation, we're primarily going to be discussing intellectual property. Just a little bit of a review, though, to begin. We have two categories of property that we're going to be focusing on. We've talked about real property rights. We've talked about the fee simple, the mineral rights, the water rights. We've talked about the conditional estate, the life estate, even a future interest. We've talked about a leasehold, and we talked about an easement and a license. We don't talk about profits in this class. At least we don't have time this semester to talk about them. And we talked briefly about adverse possession, squatters' rights, and then we went through several different Texas statutes. You're not expected to know the length of time. Just know that depending upon the color, the colorable claims of the squatter, that affects the length of time that the property owner has to complain about the squatter before the rights to the land are sacrificed to the real title holder. Okay, so let's look at condemnation. This is the same concept as eminent domain. This is when the state comes in and says, we need this land for a particular purpose, and as I say here in the Texas Constitution, of course in the U.S. Constitution as well, there has to be adequate compensation for that. This is where we stopped last time. We talked about the condemnation petition, the process that the state of Texas would go through, and about the appointment of special commissioners. I'm not expecting you to know anything about the Texas property rules. Just know there's a process that has to be followed. Okay, now we are up to intellectual property. We finished the real property topic, and we're going to start on intellectual property. We're going to talk about 4 different types of intellectual property. Let me pause here for a second before we get started. We offer a course in the Paralegal Studies program that is on intellectual property. And we talk about all 4 of these topics in great detail for a semester. It's a 3-credit course. If you have an interest in that course, I encourage you to sign up for it. We offer it most semesters. And if you have any questions about it, please feel free to come and talk to me. I'll be happy to share with you what I know about this topic. If you have an interest in the topic of intellectual property, just so you'll know, this is an area of the law that is growing significantly. It is probably the category of law that people who practice in that area receive the highest incomes. And in the Dallas area, this is a growing area of the law for lots of reasons which are beyond the scope of this class. But it's a smart area to explore if you're considering a career as a high-tech professional or as a paralegal or as an attorney. Trademark. This is one category of intellectual property. A trademark, we all know, the classic, of course, is the swoosh that you have on a Nike item. It's a distinctive mark, word, design, picture, or arrangement. When you see the golden arches, you automatically think McDonald's. When you see the swoosh, you think of Nike. Other color combinations or symbols make you think of that product, and that is an important marketing tool, and it is a right, once it is trademarked, that a company has and they want to protect it. Related to the concept of trademark is the idea of trade dress, and that's the overall appearance of the product. It's more than the trademark, but certainly the concept of trademark is part of trade dress. And trade dress is also entitled to the same protections as trademark. So if I wanted to invent a new soft drink and my bottle looked just like Coke, the design of it, the colors, the font, the presentation, except that instead of saying Coke, I spelled it with a K-O-K-E, I would be infringing upon the trademark, certainly, but also upon the trade dress of Coke. And they would not be happy with that. So that's one category of intellectual property. Our next is copyright. This is the protection of creative work, music, both fiction and nonfiction, computer programs, movies, plays, really anything with a creative aspect. The things that a work has to have in order to be copyrightable is it has to be fixed. It has to be a static item, and it must be original. So if I copy or riff on something that you have prepared, but it really doesn't involve original material, you perhaps can copyright what I infringed upon, but I can't copyright it. And of course, it must be creative. There has to be some level of invention involved in the process. A copyright automatically arises in the law, but you do have to make the mark. You've probably seen it. Here we go. Let's see if I can make it here. It's a circle with a C in it. You'll also see the trademark symbol. I didn't do this before, but the T. Not so good with my writing, but you get the idea. Once you have copyrighted a work, you have the rights to that for 70 years. That's one of the reasons why you may see, for example, if you were to go to Amazon or find very inexpensive versions of books or other media that is over 70 years old, and that is because the owner of that or the heirs of whoever initially created it no longer have rights to control how that item is being used. There's a fair use doctrine. This is very important in academia, and that means that I can quote a small portion of something that is copyrighted without getting the permission of the person who holds the copyright. If the purpose for that small use is for criticism, comment, news reporting, teaching, of course that's where we're focused on in this course, or research. That's the fair use doctrine. So we've talked about copyright and trademark. Let's talk about patents. Many times intellectual property attorneys are called patent attorneys, or this area of the law is called patent, but certainly a patent is a type of intellectual property, is not the entire field. So what is a patent? It's a product, process, or invention. It can be a machine. It can even be something living, like a plant. And there are three things that it has to be true about it. First of all, it has to be new. There has to be something about that patent that is novel. When I say novel, I don't mean like a work of fiction, but something that has not been thought of before, some innovation. And it has to be useful. It has to perform some function that is beyond what the item, other versions of that item have been able to accomplish. And it must be non-obvious. So if I go out and invent the wheel, well, gee whiz, a lot of other people have invented the wheel before. So if it's, when you look at it, you're like, well, of course, anyone would know to do that. You can't patent something that is manifestly something that can or should exist. Once you get a patent, you have 20 years from the date of the application to enjoy the marketability of that item. You get royalties from anyone who wants to use that item. The only restrictions is that you may not use your patent for an illegal purpose. So if I invent some kind of device but I use it to manufacture methamphetamines or something like that, then obviously even though I have a patent, I'm using it for an unlawful purpose. Some illegal purposes are a tying arrangement when the holder of the patent issues a license to use the patent object only if the licensee agrees to buy some of the non-patent product with the holder. You can't have the tying. So, for example, if Microsoft invents a new software and then says, and you've got to buy this non-patented book that talks about the software. And so in that way, Microsoft is trying to use its monopoly power, because, of course, a patent is a monopoly, to exert monopoly profits from the situation. And to some extent, obviously, the person with the patent is able to exercise the monopoly power, but extending it to a tying arrangement is beyond the pale, it's beyond the scope. And then the other is kind of related, is the idea of cross-licensing. It's when two patent holders license each other to use their patents only on the condition that neither license anyone else to use their patent without the other's consent. So again, this is a way to control. And again, that's exerting is considered an unfair use of that monopoly power. How do you obtain a patent? Well, first of all, you need a patent attorney. Most attorneys are not licensed to practice in front of the U.S. Patent Office. In fact, they're few and far between. I certainly am not. And as I was saying before, that Dallas is getting a patent office, or I think regional or district patent office. I'm not sure which one it is. But you have to get an attorney in that field to practice. Attorneys can't, just because you're licensed to practice in one area doesn't necessarily mean you're licensed to practice in all areas. So once you find an attorney that's licensed to practice in front of the U.S. Patent Office, then there will have to be a patent search to make sure that nobody else has already filed a patent application or been issued a patent for that particular area. If none exist, then a patent application will be completed and it will be filed with the Patent Office. After the Patent Office has the opportunity to review the application, then it will decide whether a patent is reasonable or not. This process can take up to 2 years, and obviously it's not automatic. If your ideas are sufficiently similar to someone else's, the Patent Office might say, well, no, this isn't worthy of a patent. You'll oftentimes see on items that you purchase that there's a patent pending. That means that they're in that 2-year window of time. They don't know if they're going to get a patent or not. So we've talked about trademarks, copyrights, and patents. Let's talk about the last category, the trade secret. This is a little different than the others because this has to do with common law more so than the trademarks and the copyrights and the patent. You don't have to do anything to create a trade secret except keep it a secret. That's the only thing that you have to do. What is a trade secret? It's a process, product, method of operation, or compilation of data that gives a business person an advantage over his or her competitors. Sounds a lot like a patent. The difference, or the primary difference, is that with a patent you actually have to file a patent application. You don't get a patent just by inventing something. You have to file the paperwork. If you don't do it, you don't have a patent. But a trade secret, you don't file anything. There's no U.S. Trade Secret Office that you have to go to. What do you have to do? Well, 2 things you have to keep it a secret. This is the big one. So if I post my trade secret on the internet, guess what? I've lost my trade secret. Somebody else, let's imagine I'm KFC, and I post the 11 herbs and spices that is used in my chicken, or maybe I'm Coke and I post a secret formula to my product, and somebody copies it. Well, because I hadn't patented it, I can no longer use the benefit of that because I chose to make it public. But if I work hard at keeping it a secret and it's stolen, or someone has hacked into my computers and found it, I'm still going to be able to assert the status as a trade secret. Another aspect of a trade secret is it really has to be something that not everybody knows. I can't hide. I mean, I can try to hide something that everybody knows, but I'm not going to be successful if it is generally known in the industry. If everybody in the fried chicken business oh yeah, of course we know what the 11 herbs and spices are KFC uses. It's common knowledge. We use the same ones ourselves. It's a no-brainer. Of course people use this. Well, in that situation, it wouldn't be a trade secret. Okay, let's talk about the differences between a patent and a trade secret. This is an issue that business people or inventors have to decide. Are they going to pursue a patent, or are they going to pursue a trade secret treatment? A patent, of course, guarantees you that you're going to be able to take advantage of that for 20 years. But on the 21st year, guess what? Anyone can use that information. But if you keep a trade secret forever, guess what? You get that advantage forever. It never runs out of time. Of course, if you file the patent, you're making it known how it's done. You have to do that, or the U.S. Patent Office isn't going to be able to evaluate whether you should be issued a patent or not. And so it invites people to challenge it, to say, oh, that's not really your patent. It's really my patent. I already invented that. So that's kind of the big difference. Can you keep it a secret? If you can't, you probably shouldn't use trade secret. If you can keep it a secret, you're confident you can keep it a secret for a very long period of time, trade secret may be the way to go. So we've talked about trademarks, copyrights, patents, and trade secrets. We've talked about the topic of real property, and we've talked about intellectual property. If you have any questions, please feel free to come to my office hours on Wednesday morning. This will be from 8:30 to 8:50 before we have our test. Good luck, and thank you for your attention. Bye-bye.